very successful in it. Alhamdulillah. He's been very successful in wills and in estate and so on and so forth. And he'll tell you, he'll work through this and he'll tell you. The other gambit of this is mirath, is inheritance rule, Islamic inheritance rule. But we'll do that presentation at another time because that's a longer day presentation to do inheritance rules, because it is important to cover the various forms of the inheritance rules. Our friend Sheikh Zaid is here, so he'll come up and say a few words, and then we'll hand it over to Brother Ibrahim. Sheikh Zaid last year lost his wife, and so it went to probate. No, it went to some other things that are very difficult to deal with, especially when you lose a loved one. So he'll come up and say a few words, and then we'll hand it over to Brother Ibrahim.
الحمد لله رب العالمين وصلى الله على سيدنا محمد وعلى آله وصحبه وسلم. اللهم علمنا ما ينفعنا وانفعنا بما تعلمنا وزدنا علما وعملا وتعليما متقبلا يا رب العالمين. We give praise and thanks to Allah subhanahu wa ta'ala always in our states of joy and happiness, and in our states of in our other states. We ask Allah subhanahu wa ta'ala to teach us beneficial things like what we are here for, and to let us benefit from the things that we learn. Allah subhanahu wa ta'ala says in the Quran, فَاسْأَلْ أَهْلَ الذِّكْرِ إِن كُنْتُمْ لَا تَعْلَمُونَ. Ask those who know if you don't. So inshallah, this is why we are here, and we have those who know. Our brother Ibrahim. And there's a lot of things that when we don't know, and we ask those who know, and this is why we are here, it becomes clear. It becomes very clear, and this is how it should be in our minds. Because don't wait until the last moment, and there are many things, and we leave those who know about it to deal with it. And some of the questions that you have, Sheikh Lauder and myself at some other time will probably be able to answer those. When you are in your house, or when you leave your house, or when you're traveling, going to Hajj, or Umrah, or some people, as we have taken some people who are here, Uncle Eric and his family, Ismail. I've always written something and left it with my wife. It was always there, and it changes. Our things always change where we live. Is a holographic will?
Yes.
It works in Ontario.
Yes.
Okay. A holographic will, or something that you write by your hand, handwritten. It's something it's a legal document. So I'm suggesting to every one of you, if you don't already have a will that's planned out, you can write something by your hands, sign it, and that would be enough. Because on the passing of my wife, there's a case, I think, in Saskatchewan. It's in the museum there, where the farmer, he was doing some work with his tractor, and it flipped on him, and he didn't have a will, and he knew he was dying. He took out his knife and he scrolled on the thing of the tractor, on the part of the tractor that he was able to. Anybody drives a tractor? You don't have a tractor, so you don't have something to scribe on. And he says, all to wife. This is in the museum here. All to wife. That was his will. Something like that. And this is your duty, because I'm assuming everybody here has something for more than 2 days, as Sheikh Daughter said. Write something and leave it. You will leave yourself, you will save yourself a lot of problems. So alhamdulillah, Allah subhanahu wa ta'ala decided just over a year and a few months ago that those who are looking at hockey, they call it sudden death now. Well, that happens in real life. And I came home and, my wife called me and she said, something bad is happening, call the ambulance, la ilaha illallah. That was her last words. Alhamdulillah. And there are a lot of things, and the reality is that there are a lot of things that you are responsible for if you're left. How about if, and this has happened before and it's always happened, if two people, yourself and your spouse, if you still have a spouse, you're traveling in a car and there's an accident, what happens if you don't have something written? The other thing that you can ask about also, and that is important, is who do you leave as the executor of your estate? And because that's not an easy matter either. Who do you leave as your executor? And people have put myself and other people in the community as executors of their will. You have to think very carefully of how you're going to put it, and you have to put somebody who's capable and who is competent of doing that and understand what it means to become the executor of a will. Inshallah, this is why we are here, to seek knowledge and to understand what it is, and we ask Allah subhanahu wa ta'ala to teach us these things and to let us better. This is the dua that I made, Allahumma alimna ma yanfa'una, to let us learn beneficial things and to let us benefit from the things that we learn. So I hope and pray that all of us who are here will learn something, will benefit from it, and put it into our lives, because the reality of matters is that one moment you're here, and we see it all the time, and another moment you're not. And if you're lucky and fortunate, your last words will be La ilaha illallah Muhammadur Rasulullah for all of us, inshallah. We ask Allah subhanahu wa ta'ala to bless all of us and to bless our families and those who we will leave behind, that we leave things in a way that is easy and for them by doing what we're supposed to do, what we are here to do, inshallah. Walhamdulillahi Rabbil Alameen wa sallallahu ala Sayyidina Muhammad wa ala alihi wa sahbihi.
Assalamu alaikum. Thank you, Sheikh, for the heavy words. Allah give your wife Jannah and all our predecessors. Thank you, Sheikh Tahir, for inviting me, and thank you all of you for attending, for welcoming in such an amazing institution you have here. MashaAllah, Allah continue it in goodness. Bismillah ar-Rahman ar-Rahim. Alhamdulillah, alhamdulillahi Rabbil Alameen. Salatu wassalamu ala Rasulullah. A little bit more about myself. Thank you for the overkind introduction, Sheikh Tahir. My name is Ibrahim Danyal. I was born and raised in Edmonton during the Wayne Gretzky days, since the Sheikh mentioned hockey. So we're hoping the Oilers continue their run, inshallah. I studied computing science as an undergrad at University of Alberta. And then came to Toronto. As I got more involved in the Muslim community and university, I realized that we needed Muslim lawyers. I encourage any young person here, or not so young, to consider law. We need more Muslim lawyers. We get our butts kicked by other communities in the Middle East, as you know which one, because we don't have enough lawyers, journalists, business people, psychologists, psychiatrists, those soft sciences. So we need more lawyers. So alhamdulillah, as I got more involved in the community, I realized we needed Muslim lawyers. I came out here for law school at University of Toronto 25 years ago and fell in love with Toronto and never moved back, even though Edmonton's still home in my heart. Today what we'll talk about is wills, as has been mentioned, and just a quick explanation of what we'll do and what we do as lawyers who do wills. So I've been practicing exclusively in wills and powers of attorney alhamdulillah, for the last 15 years, and a few years before that, several years before that on Bay Street. So we practice Ontario law. So when you do a will in Ontario, as many of you know, we're drafting an Ontario will. But because we have testamentary freedom in Ontario under the English system, we can do whatever we want, generally speaking, for the most part. So there's a famous case of somebody gave all their money to their cat. A multimillionaire gave all the money to their cat. You don't technically give it to the cat, you give it to a trustee who manages it for the sake of the cat. So if non-Muslims can give all their money to a cat, then we can do our distribution Islamically. So that's how we can do Islamic wills within Ontario law. So will law is provincial. You know, you have federal laws. Our criminal law in Canada is federal, but will law is provincial. So healthcare, education, wills, property is all generally provincial law. So I'm just an Ontario lawyer. Much of what I say applies to the rest of Canada, but not Quebec. Quebec has its own French law, which may be slightly closer to Islamic law in inheritance law from the Napoleonic Islamic influence on Napoleon. We won't get into those details. The main thing that has kept all of this interesting for me for the past 15 years is the tension between Ontario law and Islamic law with respect to inheritance. So what do I mean by that? The Ontario society, at least the modern, postmodern Ontario society, as you know, is based on the nuclear family. So it's husband, wife, and kids. But the Islamic law of inheritance is based not only on spouse and children, it also includes parents, siblings, the more extended family. So that was especially relevant in a traditional society where there was a whole, as you know the phrase, it takes a whole village to raise a family, to raise a child. So all of the family was the extended family, not the nuclear family. Now the problem for us in Ontario and Canada, income tax law is federal, estate, what Sheikh referred to about probate law is provincial. So there's this tension between how the laws are drafted here, which is in between husband and wife. So you get tax rollovers, which means deferral on paying of taxes, but that only applies usually between husband and wife. But in Islamic law, you give the property more broadly. So the trick of this science, I would say, and an art of Islamic laws in Canada, in the West generally, is how to optimize all the tax stuff, all the equity issues, while at the same time being guided by Islamic law, inheritance law, and staying true to those principles. So alhamdulillah, I've been blessed to consult scholars for the last 15 years on this, all over North America and some visiting from overseas, how we should optimally do this field. And subhanAllah, myself and a few other lawyers, and I think alhamdulillah, I'm the only one who practices this as exclusively as my practice, meaning Islamic wills. I don't do real estate. I don't do anything else except wills, Islamic wills, and powers of attorney. But we're the first generation of Muslim lawyers in conjunction with scholars to how to navigate this field in an optimal way, inshallah. So we're discovering it as we go along to some extent. So I just wanted to give you the broad kind of rubric of how we are trying to deal with this field before we get into the details. The last point is that when you start this field, and I have to admit, I'm almost ashamed to say when I first started studying this area, or I am ashamed to say, when I first started studying Islamic inheritance law 15 years ago, subhanAllah, I was like, why are all these strange rules here? Why don't we just give everything to the husband and wife like they do here for the most part? And that's not actually entirely true, but generally true even for here. But the more you study this Islamic inheritance law, the more you see how clever and amazing this field is. All these rules of blocking, like which relatives get something, how family members are blocked, all these conditional rules. It's complicated. The basic principles are simple. The details are complicated. And the point is, first point, if somebody just invented this law, they would have to be a PhD or postdoc in inheritance law to just have made this up. Like, you would have to spend years of your time just coming up with these rules that are explained in a couple of ayahs very succinctly, but amazingly detailed. And it's one of the few places where the Quran goes into so much detail, because Islamic inheritance law is such a haqq Allah. It's such a right of Allah on us when we die. Allah goes into so much detail. Why does Allah do that? Oh, we speculate. We can, inshallah, give some speculation later that the scholars get into. But the point is, this law is so cleverly come up with. Whether you agree with it or not, whether you think there's a creator who sent this or not, that's between you and the creator. But for somebody to have invented this would have taken 10 to 20 years of their life full time. I have no doubt about that, because of the amazing cleverness of it. And you'll see a quote, inshallah, from somebody about that, your Orientalist. The last point of how does Islamic inheritance law fit into other areas of Islamic law in terms of equity and justice. What I realized, subhanAllah, over the last 15 years is Islamic inheritance law is a critical part of justice and equity in Islamic law. It's not just Ontario law, it's just one part of law and disjoint from all other areas of law. It's actually integrated into having no riba, having zakat, and having Islamic inheritance law. I would argue that those are the three financial principles of Islam, of justice through finance in Islamic law, that you don't do interest, you spread out inheritance so you don't monopolize it among just one person, and you give zakat, so you have a excess wealth tax. When you combine these things, you create a just society. So Islamic inheritance law is part of all that. So sorry, I won't get into the abstract too much anymore, but just to give you what I discovered, subhanAllah, by God's grace, the reverence we should have for this field, subhanAllah. And that doesn't mean that we don't have to be careful how we implement it. One sheikh said, well-known sheikh in GTA said, we shouldn't leave money on the table for the taxman to take. In other words, we should practice Islamic inheritance law, but without being stupid about it, in short. So this hadith, as was mentioned, it's amazing that 1400 years ago, Rasulullah told us this. Now, why is this particular for us? And subhanAllah, I think Rasulullah intended this for us as a minority in particular. And I'll say why. In a Islamic society, there's Islamic inheritance by default. So if you die without writing anything, the Islamic law determines who gets what. So the question is, why did Rasulullah say this when by default, if you die in a Muslim majority country even today without a will, the Islamic distribution is known. So why did Rasulullah say this in particular? So of course there's a bequest. As you know, in Islamic law, you can give up to 1/3 to somebody who's not already getting a mandatory share, but cannot be more than 1/3. And that's from the famous hadith where Sahaba wanted to give more, and Rasulullah kept reducing it until he said only 1/3. And then he added, sallallahu alaihi wasallam, it's better to spend on leave to your family and not leave them destitute. Subhanallah. But why does this relate to our condition as a minority? Because if we die, as both sheikhs said, we don't want the government to be involved excessively, and you will not have an Islamic distribution. So the bequest in our context is not just the 1/3, it's the entire distribution. So this had in the sense that if we don't write down and do a will, either yourself or with a lawyer, and I don't recommend doing it by yourself, and that's not because I want your business. You don't have to come to me, go to any lawyer. But it is a minefield even for lawyers. Lawyers who dabble in this field get basically sued. It's one of the highest areas of litigation for lawyers that they get sued because there's, number one, it's tricky, and number two, emotions are high when people die. Siblings fight among themselves, not just for the money of the parents, but who loved whom which of the children the parent loved more comes down in wills. There's a case about 2 years ago in Ontario where the two siblings fought for a $50,000 artwork piece of the late father. Guess how much they spent on lawyer fees? One spent $150,000 on lawyer fees, and another spent $200,000 on lawyer fees for the $50,000 painting of the father. But it wasn't really about the painting. It was about the love of the parent and dominance over the sibling. I'm not a litigator, so I don't make anywhere near that kind of money, and wills don't cost that much. The real money is in litigation about fighting over stuff. That's the other beauty of Islamic inheritance law. It reduces fights tremendously because everybody knows what they are getting, and you cannot top up your favorite son or your favorite daughter's share from the 1/3. The people who are already getting a share cannot be topped off. The 1/3 can go to an adopted child, grandchildren through daughters, a niece or nephew, or sadaqah. So this hadith, and I only realized this a couple of years ago of the last 50, not in the early part, that this hadith is, I think, particularly directed to us, subhanAllah, as minority communities 1400 years later, subhanAllah. Allah knows best. So generally, now I'll start getting into details, and we won't get into all the details of the slides, just the highlights inshallah. So what is a will? We generally know what a will is. It's a legal declaration or document. What can you do in a will? Of course, you can give your property to whom you will, but you can also do some other things. You can appoint guardians for your minor children. So if you have children under 18, you should have a will naming who takes care of your children, custody-wise, not their money, not the estate. Estate is up to the executor to manage. The executor is the person who executes the instructions in the will. But something even more important is who takes care of your minor children. And it may be the same people as the executor, or it may not be. And also of how you give your money in the will. Whether you give it absolutely, which means you just gift it to the person from your will, so they get it and there's no strings attached, or you put it into a trust. So if you put into a trust, then what are the conditions of the trust? So for minor children, generally we give in a trust, or we always give to minor children in a trust. Even children under the age of 21 or 23, we still put it in a trust because you don't want your 18-year-old son, if the parents pass away unexpectedly and the 18-year-old son gets $500,000, he might blow it on a sports car. I have a 17-year-old son, alhamdulillah, so I would not want to give him any significant inheritance under his control. So we talked about the basic things of what we can do in a trust, in a will. I just want to talk about from an Ontario's perspective, what else we can achieve in a will. So we can reduce probate taxes. So probate taxes are taxed. So this isn't Trudeau's fault if you hate Trudeau now, which we should on Palestine, but he's not responsible for probate taxes. Probate taxes are the domain of the province. So this is up to 4. So after we pass away, there's a probate process that most people have to go through. Sometimes you can escape. So we can't generally escape probate process, but you can reduce the taxes and the delays in it by doing a will, basically, in short. So a will can also reduce probate taxes. What are those? Those are 1.5% in Ontario. So if you pass away with $1 million, there's 15,000 taxes, for example. If you pass away with $2 million or real estate worth that, it's $30,000 and so forth. Also, if your child is receiving or your adult child or your spouse or one of your beneficiaries is receiving ODSP benefits, the Ontario Disability Support Program benefits, you cannot or you do not want to give property directly to that beneficiary because they'll lose those ODSP benefits. Instead, you have to do something called the Henson Trust. So be careful if any of your beneficiaries, meaning the people who receive stuff in your will, are on ODSP. So that's some of the other things particular to Ontario and many provinces that we can do in a will. The first misconception I want to raise, or more generally, what happens what is actually the process that happens? So if we die without a will in Ontario, that causes more delays for the processing of your assets. There's no executor named, so somebody has to come forward and apply to be the executor. And what if two different parts of the family, or two different siblings, or two different children are fighting over to be the executor? In addition, if you don't have any heirs, which I have a few cases like that where it's a single person with no family, subhanAllah, if they passed away without a will, ultimately the money could go to the government. But that is in a very rare case. There's still a default distribution. The other misconception is that your spouse gets everything in Ontario without a will. That's not actually the case. Most couples in Ontario give everything to their spouse. Islamically, you have to figure out how to do that so that it's not a sin to do that. And that involves consents and so forth. We'll talk about that. But by default, if you pass away without a will in Ontario, whatever your background, your spouse does not get everything. So that's good and bad, depending on the context. Most importantly, if you have minor children, as I mentioned, and you pass away without naming guardians, then it's going to be up to a judge, a non-Muslim judge, to decide who will take care of your children. And without your input from the will, that's not a situation we want to have or be in for our children, God forbid. How do we select guardians? It should be somebody on the same wavelength as you with respect to Islamic values, and should be also somebody capable of taking care of young children. So maybe not grandparents if they're not fit enough for that job. The other thing, as I mentioned about trusts, we often give trusts for children under the age of 21, 23, 25. So I mentioned this earlier about testamentary freedom. The only restriction on it in Ontario is that a legally married spouse can take half of your estate if he or she doesn't like what's in the will, in the sense that the law considers it a divorce. So I'll explain how this applies to Muslims. So in Islamic law, the share of the wife is 1/8 or 1/4, generally speaking, and the share of the husband is double that, so 1/4 or 1/2, depending if you have children or you don't have children. So if you decide to give less to your wife or husband than what's possible in Ontario, he or she can cancel your will and take more, basically. So if we do the Islamic inheritance in the will, we should make sure that both spouses are on board with that, inshallah. If you're not, what happens on death is the Ontario law can consider death like a divorce, and if you have a divorce, each person kind of gets half. It's based on the increase during the marriage, and you get half of that, and the richer one pays the less rich one an equalization payment. I don't mean to get into too many details. All I'm saying is that there is testamentary freedom in Ontario, but there's some restrictions for legally married spouses, and this is good and bad. It was done to protect widows. It was only brought about 30 years ago or 40 years ago now for Ontario law, and it's to protect widows primarily. And it actually indicates that total testamentary freedom is not just. You could, like I mentioned, you can give everything to the cat and deprive your children. Or you can not include your spouse, which is unjust. So the Islamic system of inheritance is, I think, a beautiful balance between a mandatory distribution for 2/3, but also testamentary freedom for 1/3. It's this amazing hybrid system, subhanAllah. I talked about the probate tax. The official name is Ontario Estate Administration Tax. There's also capital gains taxes on death. So let's say you pass away owning all these assets, whether it's stocks or real estate assets outside of your principal residence. Your estate will have to pay a tax on the gain of those assets. So let's say you bought the asset as the house at $100,000 and you sold it, and when you died, it's worth $1 million. So the gain was $900,000. So there's a taxable amount that will be payable on that by your estate. This is not for your principal residence. So don't worry if it's just your one house that you own, that you live in. This is for extra houses. That's the federal or national capital gains taxes on that. I just want to highlight some areas because everybody's in different situations. Some people don't own many assets, but some people, mashallah, own multiple houses and businesses. And so I'm trying to just highlight things for different people. As I mentioned, the estate tax in Ontario is 1.5%. Now, how do we reduce these taxes or defer them? So just a quick rule, it's good to keep, for estate administration tax purposes, one thing, if you can remember from the seminar, just practically, is keep your house joint with your wife, with your spouse. This may be, there's some good and bad in this, but generally it's good to do this because you avoid paying the probate tax, that 1.5% tax, twice. This also applies for bank accounts. Now, it doesn't matter if you have $1,000 in the bank account, but if you have $50,000 in the bank account, you may want to keep it joint to avoid this 1.5 probate tax. This joint, this is one of the rollovers I was talking about and the tension of the laws here, which are made in favor of a husband-wife unit, not the whole extended family unit. But in short, if you have significant money in a cash bank account, keep it joint with your spouse. Now, I know many Muslim women should control their own money and may want to keep their bank accounts separate. I'm not saying to go and invade that independence, but just be aware of the tax consequences of not having a joint account or not having the house joint. If you have a business, I won't get into too much detail on this, but if you have a private business, like a professional corporation, if you're a doctor or accountant or a dentist, and if you own, or you have a business, a running business, like you own a store, and that is incorporated business, or you have a dealership, like you sell cars or whatever, and you do it through a corporation, or you do real estate investment through a corporation, then you have most likely a private Ontario corporation. And there's a whole different way to totally avoid the probate tax. But we have to do two wills, a primary will and a secondary will, or we call it a probate will and a non-probate will. Basically, we put the private corporate shares in a will to avoid the probate process of Ontario, to avoid paying the probate tax. So it's a giant loophole that was exploited by lawyers and accountants about 20 years ago in Ontario, and no government has fixed it, because the government laws are generally written by the rich for the rich. So no government has fixed this. But Muslims, we should take advantage of this. Why should, as the Sheikh said, don't leave money on the table for the taxman to take unnecessarily. So if you own a private business or have a professional corporation with significant assets, only worth it if there's about $300,000, $400,000 or more of value in the private corporation. Then it's worth doing a more complicated legal process to avoid the probate tax. Henson Trust, that's if you have, it's also known as a fully discretionary trust. Henson Trust was where the lawyers and accountants created the loop or discovered the loophole. The government tried to fight it in court, but they lost, and they haven't fixed it. And this is a good thing they haven't fixed, because this is for disabled people to avoid losing their ODSP benefits. So this is a good loophole, but you should you need to do a proper accounting for that in your will. Also, insurance trust. So insurance is problematic in Islamic law. I'm not saying that you should have insurance at all, but if you have it, and sometimes you have it through work, those aren't usually large policies. But if you have a separate insurance policy, then you want it to benefit the children. There's a misunderstanding or misconception that the minor children will benefit automatically from the insurance policy. They won't. It gets frozen basically into by the institution until the child turns 18, and then the insurance company writes like the $300,000 check to the 18-year-old teenager, which is not good, as I mentioned. So if you have a significant insurance policy outside of work, we should do an insurance trust. But I'm not saying that you should do that. Also, U.S. estate taxes, I won't get into details. There's no estate taxes in Canada. So basically the billionaires got rid of estate taxes in Canada. Estate tax is like an inheritance tax. It basically means, why should the billionaire pass on his money to his children without any benefit to the rest of society? So most rich countries have estate taxes. The US, UK, Canada is one of the only exceptions. So that helps normal people, but it's really designed for rich people. Like in the US, it starts at $10 million US. In the UK, it's 1 million pounds. So it's well-off people. So it's a good system. It's a subset of a zakat, I would say, because it's a wealth transfer tax. So it's unfortunate we don't have it in Canada. We should have it in Canada, inheritance estate taxes. But how this affects us is that if you have a U.S. property, like a condo in Florida, or you own a U.S. stocks in a U.S. brokerage account, which many people do, or a good number of people do, this can affect you. So just be careful about U.S. estate taxes. I won't get into details, but it's a ratio of your Canadian assets versus your overall U.S. assets overall versus your global assets. There's something called inter vivos trust. So there's two types of trust: a testamentary trust, which is something you do from a will, and the inter vivos trust is while you do something while you're alive. Vivos means from Latin living, basically. I won't get into details of this either. I'm just trying to touch on as many issues as possible, just so you know, oh, this might apply to me, this might apply to my parent, my sibling, and so forth. I won't get into this. It's basically, if you have a business, how to defer taxes for the future. I give presentations for lawyers and accountants also on Islamic wills and stuff. Before we get into Islamic wills quickly, we'll talk about powers of attorney. So powers of attorney are like a will, but while you're still alive. So consider, you know how there's life for Muslims, different stages of life, in the womb, while we're alive in this earth, and then after we pass away. Similarly, from a estate and powers of attorney and will perspective, there's issues before death certificate and after death certificate. After death certificate, the will takes over. But of course, the will doesn't do anything while you're still alive. It's just a piece of paper. It's only activated through the probate process after the death certificate. Prior to death certificate, we need things to manage our affairs in case, God forbid, we get into an accident or we get seriously ill and we lose capacity. So you go into a coma, or you get surgery, or you get dementia, God forbid. You need something to manage your affairs while you're still alive, and that's called a power of attorney. And there's two types. One is for property, one is for healthcare. So in addition to the will, and probably even more important than the will, are the powers of attorney, because there's no default person named to manage your affairs of property meaning your house or your bank accounts, if, God forbid, we lost capacity while we're still alive. The other things we put into the will is funeral instructions. Now, this is especially important for people who have non-Muslim family members who may have different opinions of how you should be buried and so forth. So it's important to put this in the will. It's not binding technically. The executor is the one who makes the decision of what happens to the body after we pass away. So it's very important that you pick the proper executor. So this is important for mixed families who have families of different backgrounds, religious backgrounds in them, or convert families. So we'll quickly go on to the Islamic will idea that I touched on earlier, inshallah. So Islamic will is similar to an Ontario will, but it has the rules of Islamic inheritance, or the shares that people get, with the option of giving up to the 1/3 bequest, as I mentioned. I touched on this, about Islamic inheritance law. The other amazing thing about Islamic inheritance law is the rights for women. So, before Islamic law, Sharia, women did not inherit. They were in fact inherited often as property themselves, alhamdulillah. Even Jewish law only gave shares to widows a life estate, which means they could use the money while they were alive, but they couldn't pass it on to their heirs, or they couldn't give it away or spend it. But the share to women is a fully vested share, which means if a woman inherits, and women automatically inherit, daughters are mandatory heirs, wives are mandatory heirs, mothers are mandatory heirs. You cannot disenfranchise those people. And Rasulullah came, he didn't destroy everything that was there before. The favored heir of the Quraysh was the son and so forth, and other male relatives, the closest male relative by blood. So that remains within Islamic law. But the clever part about it was, or the way it was implemented so cleverly, was that the Quraysh would never have given that up. We're talking about this from a materialistic perspective. Allah could make whatever happen. But psychologically, the Quraysh would not have given that up. But instead, so Rasulullah didn't say you can't give to your son, or the son is not the residual heir, the one who inherits what's left over. But instead, Sharia cleverly inserted wives, mothers, and daughters to get shares, to give them significant equity and inheritance without losing some of the tradition. So this is just as a side note of a clever way. Now, we know the share is generally half. It's not always the case that the woman shares half. And sometimes the biggest heir is the daughter, or the daughters collectively. So women don't get less in Islamic law as a general rule. It's only women vis-a-vis the same relationship. So daughters get half of what sons get, wives get half of what husbands get, and so forth. But that doesn't mean that a woman is always getting less than a man in the inheritance. It depends who's alive. But for some reason, Allah put wives getting half of husbands and daughters getting half of sons. So that is, of course, in a modern context, we have to figure that out. But from a historic perspective, the fact that women, daughters, and mothers got shares that were in their own name, that they could give away, spend, or invest, and they were significant shares, not just token shares. This was revolutionary in human history, subhanAllah. I'd just like to do a quote from this old Orientalist. He said, Professor Rumzi, from over 100 years ago, he said, the Muhammadan, which is the Islamic law of inheritance, comprises beyond question the most refined and elaborate system of rules for the devolution of property that is known to the civilized world. I get goosebumps when I'm literally getting goosebumps now because I'm such a nerd about this stuff. But this is the same discovery that I had when you got into it. After a few years of studying this, subhanAllah, you really realize how amazingly clever and brilliant and wise and equitable this distribution is. So can we write an Islamic will in Ontario? As I mentioned, we have testamentary freedom. So for the most part, yes. But how we do it matters because of the tax and equity issues in our society. I mentioned this about the limitation of the legally married spouse. Oh, I should say that the spouse does not have to take the half. The spouse just has a right in Ontario to exercise that. But they're not obliged to do that. So if your husband or wife is only getting a quarter or an eighth, they can accept that. They don't have to reject that. So we can still do the Islamic wills, but your spouse would have to be on board. But there's a whole other discussion about your spouse being on your primary residence with you, which is a good thing, which we can inshallah maybe get into in questions, if there's time for that. I mentioned the rollover. So for RRSPs, I just want to mention one more important thing to take away from this seminar. So the first thing was just practically have your house joint with a spouse. Second, and these are from an Ontario law perspective or federal law perspective, your RSP. Most people or many people have an RSP. Please make the beneficiary designation spouse. The reason is, if you don't make it the spouse, there's a huge income tax hit, up to 40%. So if we start doing the the RSP into Islamic shares, and so it goes to your parents, your children, adult children, your spouse, and not just the spouse, you could lose 40%. So if you have 100,000 RSP, you can lose 40% to the government right off the top, because the rollover, the tax deferral, is only to the spouse. So how do we deal with this? We may give from an Islamic law perspective, and this is what I was talking about, the tension that makes it interesting and tricky. So let's say you have a $100,000 RSP. Maybe we give that $100,000 RSP fully to the spouse, but then we reconcile that with the other assets, if anything. Let's say you had cash of $50,000. So maybe we give the cash to somebody else. In the big picture, we're figuring out the Islamic distribution. But each asset, how we give it, we don't want to give it in a stupid way, that we lose all 40% to the taxman. So we have to reconcile all the assets with the tax issues and equity issues. Equity issues I'll get to a little bit. So should we give half to this daughter versus the son? So no scholar I know has said that we can make it equal without the consent of the son. So we have a lot of flexibility in Islamic inheritance law, and this is the scholars, Sheikh Dahir and others can get into this more, but I've read myself, but only in English. I don't speak Arabic. Texts from like 600 years ago, where the scholars talk about with consent, a lot of things is possible. So with the consent of heirs, you can equalize shares. There's certain rules and conditions you can't coerce. There's a difference of opinion of when you need this, you can give this consent. And we have different opinion from scholars in North America about when we can take advantage of that consent. But this is the flexibility that makes us, because let me just give you an example. Let's say it's husband, wife, and kids. Let's say your parents, unfortunately, have passed away. So it's you and your spouse and the kids. And your kids are small. Now, the majority heirs in Islamic law are the children in that scenario, because the wife only gets 1/8 and the husband only gets 1/4. So 7/8 or 3/4 are going to the children. But let's say the children are minor. What would happen then if you give the majority of your estate to your minor children? The Ontario government gets involved, not in a bad way, but in a supervisory role. They want to make sure that the orphan is getting his or her share. So this is a good function of the government. However, we as Muslims do not necessarily want the government to get involved in that unnecessarily. So many scholars have advised you can give everything to the spouse, but with certain conditions. That the spouse takes an oath to do certain things, i.e. to spend from the extra inheritance on the children. And then if there's excess left over, divide it Islamically at that time. But if you have spouse from a previous children and you have the children from a previous spouse and you're remarried, now you have new children or no children, then it gets tricky if your spouse gets everything and there's children from a previous marriage. So we can't always do these types of things. But what I'm trying to just give you in a quick, in relatively quick hour or whatever we're doing today, is that this field is complex, both the Islamic inheritance part and the Ontario law and the federal tax law, Ontario tax law, and equity of should we be giving less to our daughters in this society when there's no mandatory way to force a son to take care of his sister. That's the presumption is that the man gets more because he has to pay the mahr, he has to take care of all the female relatives if they need assistance, and that a qadi can enforce this. And we know that I think Rasulullah Sallallahu Alaihi Wasallam himself enforced a Sahaba to take care of his wife because the wife complained that he wasn't spending enough on her. So we know the duty of maintenance. So But in this society, we give double to the son, and what if the son is a bum and doesn't take care of his sister, and so forth? So we have to figure all this out as scholars, number one, and then practitioners of Ontario law. And I'm not a scholar in Islamic law, just a practitioner of Islamic inheritance law, but this is why we consult the scholars of what we do. How do we do these scenarios? So some ways to mitigate these issues are, as I mentioned, the consent. So the son can equalize with his sister, or a brother can equal. Like if you don't have children and your siblings are inheriting, then, or you don't have a son and your siblings are inheriting, then the brothers and sisters can equalize if all the brothers consent to that, and so forth. If you have insurance, just another practical thing. I'm not saying that you should have that. It's good to have. It's not good to have life insurance. But if you have it, especially through work, then maybe you can give all of that money to your daughters, and to compensate for the daughter getting less in the Islamic estate, because some scholars say the insurance is outside of Islamic, your wealth, in a practical sense, because it's more like a third-party contract to pay, and you never know if they're going to pay anyway. But if they're going to pay, let it go to your daughters. It's not technically your property from an Islamic sense. So if you have life insurance through work, which many people have as company benefits, they can increase the daughter's share or the wife's share that way. The 1/3, like I said, for adopted children or non-Muslim parents for a convert, they could help their parents or adopted children that way. Adopted, of course, Islamically means that we don't hide their lineage, but in Ontario we call it adopted. We should say foster more, but that's a different thing in Ontario, as you may know. Charitable donations. So remember, the 1/3 is the maximum, and it's better to spend on your family, especially if you have a mortgage, unfortunately. But if you're able to give from your will, that's good too. In Canada, you can write off all the income tax of your last year of life by making a donation in the from the will to the masjid, because it's a registered charity, or another registered charity like TCMV, Canadian Muslim Vote, whatever your choice is. But remember, if you have a debt, mortgage debt or other stuff, be reasonable. But Islamically you can do up to 1/3, and sadaqah is better during your lifetime, when it hurts, basically, because it's hurting you, not your heirs. But if you have a lot of wealth, alhamdulillah, mashallah, please consider sadaqah from your will. And even if you don't have huge wealth, you can give something. So what is the process now of practically moving forward? So what I do normally is I send out an email which explains a little bit of what I just said in a one-page email. And then I send questions out. It's your demographic info and info about your assets and your debts and so forth. And all that is confidential, of course. Then we ask you, and I consult with you, of who could be a good guardian or executor. It's better if the person lives in Ontario, for example. You don't have to be like a financial genius to be an executor. You just have to be a normal person who can manage your bills and pay your taxes and so forth. Obviously, you have somebody more skilled, so you don't need to be a lawyer or accountant to be the executor. It can be a competent person in your family. It's a lot of work, so it's good to make the imam do it, but it's more and more work for them, and it's not an easy job. So I wouldn't burden them with it unless they want to do it, subhanAllah, but they might accept if you have no alternative. And I rarely am the executor as a lawyer also. It's a lot of responsibility and a lot of work. So, we have to consider tax and trust issues, as I mentioned. So remember, a trust there's two ways of giving, absolutely, where you just give the money or your asset in the will, or a percentage of it, a fraction of it, like 1/4 to my husband, so for example. That's an absolute gift. The trust is where you give it for the benefit of the beneficiaries of your children, for example, but they don't control it until they're a more mature age, like 21 or 23. Then we draft the documents, the will and powers of attorney. Then we send it to you for review, and then we execute it, which means sign. And now, because of COVID, they changed Premier Ford changed the law of Ontario. So now we can do this whole process remotely. But I'm based out of Mississauga. If you're in Mississauga or Brampton, it's better to do it in person. But we start the process off remotely. I just want to give an example of the share of the daughter to close. So let's say a woman passes away, and this is Islamic inheritance context. Say a woman passes away with a husband, a father, and a daughter. So 3 heirs: husband, father, and daughter. No other heirs, or no other closer heirs than that. So no son in this case. Husband, father, and daughter. So who gets the most? Guess who? The daughter. So how you do it is you give the daughter the fixed share. Because there's one daughter, she gets a half. If there's daughters and sons, they share what's left over. But if there's only one daughter, she gets a half. 2 or more daughters get 2/3. But let's just continue with this example. Father, husband, and daughter. The daughter gets a half. The husband gets 1/4 because there's a child. Because the woman who died had a child. So he gets 1/4. What's left over goes to the father, the residual, the closest male relative by blood. Sometimes the sister is actually the residual heir, so it's not always the male, but usually the male. So the summary of this case, this example case: daughter gets a half, husband gets 1/4, father gets left over, which is 1/4. So who gets the biggest share? The daughter. 1400 years ago, imagine in a patriarchal society of the Quraysh, the daughter, even if she's an infant, even if she's not a noble woman, she got 1/2 of the entire estate in her own control. And this is how Muslim women of the past set up waqf endowments. Many of the universities were funded by Muslim women because the good Muslim men at the time took care of the women financially, so she could have excess capacity to invest in endowments. This is amazing. So, and nobody could take her share away. If you try to, I know what happens. My parents are from India. If the brothers steal all the inheritance, not just double, they take all of it and the women don't get anything. This is so un-Islamic. There's Ottoman cases where this happened and the woman went to the Qadi, and you can read these Ottoman cases, and the Qadi restored her rights. But if somebody doesn't know that this is happening and doesn't know that they have these rights Islamically, they don't go to the Qadi, or the Qadi system is not functioning. So just want to close with that example of the amazing part of Islamic inheritance law, that 1400 years ago, a young daughter of not nobility could get 50% of the estate over the father and the husband, who you would think would dominate or did dominate the society. I'll close there. Everything I said today is not legal advice. It's just general advice, so don't use it as legal advice. Don't blame me later. I ask Allah to make sure that I didn't misguide anybody in any way. Allah forgive me if I did. And so thank you for attending today. Thank you for your attention. And if there's time for questions, just before I forget, if you'd like to get more information, just put your name and email address here, and I have my card here. I should tell you about the costs of doing a will normally. It's about $600 for the first will, and then, well, it's $695, but I can give a discount for this seminar, and powers of attorney about $100 each. The spouse's will is half of that, basically. Now, if we do corporate wills, that's more expensive and so forth. Now, why should you do this? Well, I would say that, like I said, you don't have to do it with me, but you spent your whole life earning your money, wanting to take care of your children. Why lose it by excessive delay, more complicated probate processes, or losing, paying more in taxes? So I would say that don't do it yourself. You don't have to come to me. But If you're going on a trip and there's no time left, definitely write it out yourself. How you do that is you write the whole thing in hand and you sign it. You cannot type it and then sign it. If you do it yourself, you have to write the whole document in hand and then sign it, as the Sheikh said earlier about the case. It's called a holographic will. So I'll just close there. Thank you again for your attention. Assalamu alaikum.
Okay, Barakallah feek. If you have questions, we'll take it. Let me qualify a few things here. So, as Brother Ibrahim said, in the will, in Islamic will, that you can dedicate a third, it's a wasiyah, you can dedicate a third to non-inheritors. You cannot in your will, in a wasiyah, send or say that this amount is going to go to a donation to one of my children. You can't, because they're inheritors. A wasiyah is someone who cannot inherit. Now, I'm going to clarify something. A wasiyah can be a non-Muslim. An inheritor cannot be a non-Muslim. Clear? So, if someone, mother, father, children, are not Muslims, they cannot be inheritors. They can't. But you can dedicate or donate a third of your estate to a non-Muslim. You understand? Is that clear?
Yeah.
Up to a third, not a third. You could do up to a third. Up to a third to a non-Muslim. You can. That's the difference in wasiyah. That's the difference in wasiyah. What else did I want to say? I made some notes myself here. Some people will say, I've done seminars on Islamic law inheritance. Some people say it's unfair. It's not. As Brother Ibrahim rightfully so said, that it is a fair and just system. Now, inheritance rules, if you pull out, many people will say, well, if you read some Orientalists, one of the things they critique Islam about is the inheritance law, that it's unfair towards women. And they bring up the son and daughter scenario. That's what they bring up. That why is the son getting a double of the daughter, of his sister? Why does that happen? When in many cases the exact thing is not, it doesn't hold. That in many cases, as you brought up the case of the father, grandfather, and daughter, she'll get more. In some cases, the mother will get more. There are some cases. If you look, the system of Islam, all the systems of Islam are a system. Inheritance rule is a system within all the other systems that work together. All of them work together. And Brother Rahim said this. So, in the Islamic system, when a woman gets married, even if she's wealthy, she doesn't have to spend a single dime in that marriage. Not a single cent. She doesn't have to, because the husband has to spend for her. Clothing, shelter, food, clothing, shelter. All the necessities. The husband has to. If Nasrul Afia, if there's children and there's no parent or grandparent and there's sons and daughters, who has the right to spend on the daughter? The sons. It's a right by Islamic law for the sons to help their sisters financially because the father's not there. So in that situation, in that realm of Islamic law, then it makes sense that the sons, because the burden of expenses falls on who? The son. The sons. The burden of expenses falls on the son. So that's why the Islamic law is set like that. It's set like that because he has to pay mahar, he has to spend for his family, for his children, and so on and so forth. The woman does not when she gets married. She does not. That's within the system of Islam. As he said though, we don't live in Islamic society. We don't. These laws are enforceable by a qadi. So a son may get double of the inheritance of his sister, but no qadi here will force him to take care of his sister. There's no judge here that will say, no, you have to, because you got more on the will. That won't happen here. It won't happen here. That happens in Islamic society because they understand the inheritance rule and they understand the delicate, while very wisdom-oriented system of Islam. Very oriented Islam. In the case that he said that the daughter inherit half and then the residual goes, why is that the case? Even though you may think to yourself, well, the father technically can take care of her. Why is that the case and not the sons and daughters? Because of the age of the father. It's the age of the father. That he may not be around long enough to take care of her, while the son and daughters are going to be close age and proximity. That's one of the hikmah behind it. It's one of the reasons behind it. So Islam, Allah subhanahu wa ta'ala, as we know, Allah subhanahu wa ta'ala is the most wise. The most wise. And the system are in place for that wisdom to take shape. For that system to take shape. And so, alhamdulillah, Brother Ibrahim has been dedicating last 15 years to doing wills. And this is just a synopsis. I know you have questions. You probably have questions about inheritance. You probably have questions about wills and so on and so forth. He'll take it. He'll take it. But inshallah ta'ala, if you don't have a will, he's the person to go to. He never came here. I never asked him to come here to. We don't benefit. He doesn't. It's a service, right? And it's a service to save your inheritors from a headache. It is. Having a will save your inheritors from a headache. And it save your inheritors from arguing with one another. That's what it does. Now, the other hikmah I want to talk about is something. My father was here. He's not here. The least that you have that will roll into inheritance, the better for you. I always say this, people. The least that you have, what does that mean? It doesn't mean that you don't earn a living, so that you don't have anything to donate. No, or to give inheritance. No, that while they're alive, and you can do so, gift it to them. Like if you have a poor daughter and your son is rich, and you know the rules of inheritance, the Murphy demands that the son will get double that of the daughter, but you're unsure about your son. You're a little unsure. You don't know. You're unsure. What do? Give it to them now. Give it to them now. Right? Or roll it into them. You can put towards trust and so on and so forth to give them that right, because then it doesn't go into an inheritance. Then an executor like myself, and don't make me executor, please, don't. It's a headache and a half. It really is. I've refused so many people unless they beg me. Like they literally beg. It's a headache. It really is. Especially when you have people who don't understand deen well. They fight. And the executor is caught in the middle. Because there's Islamic law that has to take precedence. Right? So that's something that you should seriously think about. Someone like Brother Ibrahim can help you with that. Right? Because the aspect of having a will, it safeguards relationship in the family. That's what it does. The most important thing with having a will, it safeguards relationships. Trust me, I've seen a lot of cases where brother and sisters have fought. Religious. They're religious. They pray. Religious children have fought over wills, over the inheritance, fought over it. They've fought over it. So you definitely do not want that to occur. And by having a will and talking to your children, talking to the inheritors openly about it, is very, very important to safeguard, relationships. It safeguards a relationship, right? And you want to protect the relationship. Now, I'll answer another question. I had it down here. Let's say in the past, your father and mother, your grandfather and grandfather, their will and their assets that came to you was not Islamically divided. It was not. Islamic divided. And I've had cases like this. Sheikh Zayed had cases like this. We've had cases. And the children come to us and say, it wasn't divided equally in the past. What can we correct? We can correct it. We can try to correct. As long as all of the inheritors are on the same page, we can go back and correct. It's work. Listen, it is stressful. I've had cases like this. I haven't slept. Because if you don't give the inheritors their haqq and you usurp it, it's usurpation, it's ghasab. It falls into the realm of ghasab. So that even in our books of fiqh, they say, if you go to someone's house and you know they took inheritance that was not there, you cannot use one of their cups to drink water out of. Because it's like using stolen property. Can you use stolen property? You can't use stolen property. So if you go to someone's house and you know they took inheritance that was not there, you cannot drink from their cup of water. Can't do it. So if you know, and we've had cases like this, if you know and you want to self-correct what happened in the past, Sheikh Zayed will come and he'll more than happy to sit down with you to do that. I have done it. It takes a lot of work because you have to work through the finer details of everything. I'm sure Brother Ibrahim can probably do as well. It is a headache, it really is. But it safeguards your father, mother, grandfather, and so on and so forth. Right? And lastly is that even if you have a disobedient child, you cannot write them out of your will. Sorry, can't. They're rightful heirs. And you cannot write out of your will a right. Ontario, I believe you can.
Yeah, but
Islamic
it's messy
law,
too in Ontario too, but Islamic.
Yeah, it's messy. But you can't Islamically. You can't. Right? You can't do it. Right? So, just be cautious of those things, inshallah. If you have questions, please, we'll pass around the form. It's up here with your name, email, and Brother Ibrahim will send something out along the lines of this presentation. He has his cards here and so on and so forth. As I said, give me a month, we'll have a presentation on inheritance laws. I've done it before, and then everyone gets to work out their inheritors as it is right now, because they may change over time. But you can work it out, and you'll see what percentage each one gets, and so on and so forth.
I'll just add on that point. My programming, alhamdulillah, came into handy, subhanAllah, because when we do the Islamic portions of the will, it's like programming, basically. You're coding, basically, like if somebody's alive, if then, basically.
Yes.
So, subhanAllah, and how we do it practically, we cover the first few cases, and then we do a general Islamic distribution. So I'm really looking forward to the seminar you do, inshallah.
If you have any questions, you have something to say.
You said you're from Edmonton, that's where I live.
That's where he lives.
Oh,
I'm wondering if you can take your whole practice and move to Alberta.
oh, thank you. I'd have to get licensed in Alberta, so it's a little bit of a hassle, but thank you. Biggest fellow.
If you have any questions, Brother Arif, Brother Azad had a question.
Yeah. So, Assalamu alaikum.
Wa alaikum assalam.
Whatever, can you please explain? I think this is a misconception amongst, brothers and sisters. So, spouse passed away, right? Let's say the mom passed away, right? And then subsequently, her husband passed away. They have a will. They have a will in place, the executor and everything. Can the executor execute the wishes of the parents based on what we have in this will?
So the executor is bound to follow what's the instructions in the will.
That's right.
So they actually cannot deviate from the instructions in the will. So not only they have to follow the instructions of the will. The problem might arise if the will wasn't drafted clearly, or if there's an interpretive issue. But if your question is the executor, yes, must follow the rule, the distribution outlined in the will.
Although both parents passed away,
Yes.
the executor can still, or they have the power to execute the wishes of the parents. You're saying?
Yes, if they're written in the will. If the parents' wishes are written in the will, then yes, the executor can and must execute those instructions.
So I was made to understand though that once both parents passed away, that the executor cannot, it has to pass through the probate.
So probate is the process to make the will usable in Ontario. So it's a separate issue of who's, maybe we'll talk after specifically, but most wills have to go through probate in the sense, probate means if this is your will, it's just a piece of paper. But to make it the will that's binding on the estate, that's going through the probate process. But if you have a will, it's much easier because you name the executors and your distribution is in the will, Islamically, hopefully, rather than the default distribution of Ontario. But maybe we'll talk after so I understand.
Okay, there's some sisters at the back, yeah?
Well,
question, what if one of the inheritors is estranged from the family and despite multiple attempts to get in contact with them to distribute their share, is there sort of a, I don't know what the legal terms are, but Islamically, is there a time frame that you can distribute, or do you have to hold on to it for a certain amount of time?
Islamically, if it's an inheritor and they're alive, you have to hold on to it, and you cannot use it. You have to hold on to it until that time that they come, and if after that time they pass away, then you would have to find a inheritor of theirs, right? But these are cases that are rare. But if it does happen, after a while, you can go to an Islamic qadi. Here we don't have it, but imams can act as qadi, a group of imams. That's a ruling from a past fatwa.
Yes.
And what they will do, they will decide how to use that money. Maybe they'll donate it in the name of the person who it should have went to, if it's difficult. But the answer to the question is yes, you have to hold on to it and try your best to find that inheritor to give it to.
If they decline, so if they do.
If you find them and they decline it, then that portion has to then redistributed amongst the other inheritors according to the shares. If they decline it, so yes, you may have someone. So it's important. Actually, this is very important. If an inheritor declines their inheritance, what happens? The executor has to distribute it according to the Islamic portion of that law, of the laws. Now, if you don't want that, let's say the son says, I got double of my sister, but I want to decline it, right? I'm rich, I'll decline it. It doesn't necessarily go to his sister, it doesn't. It goes through the Islamic inheritance again. Unless he says, yes, I'll accept it, but then give it to my sister. You understand?
Did you write your name?
It's a very, very fine fiqh rule. This rule, a lot of people don't understand. Fiqh is very detailed. When you talk about fiqh, it's very detailed. So you understand the mas'ala. He goes, your son inherits, he's rich. He says, you know what? I don't want it. I don't want my inheritance. I decline it. What happens to it? The executive can't choose someone that it goes to. No. It goes back through the eighth, the quarter, the half. That's what it goes back through. Right? It goes back through that. But if he actually wanted to give it and thought that I'm going to give it to my sister or my mother, whatever, he can say, okay, no, I'll accept it, but then give it to so and so. Then it doesn't go back through the rules of the inheritance. Very, very fine detail.
Thank you, Sheikh. I just want to add from the Ontario perspective, the executor, if the heir is a valid heir in the will, in the Ontario will. So we do Ontario wills, but we include Islamic rules in them, basically. The executor is a fiduciary, which means they have a responsibility to the beneficiaries and the court. So the executor, just like Islamically, they cannot just do what they want with it. And let's say they can't find the heir. They have to get the approval of a judge of what to do with that money. And there's certain rules of how hard they tried to find the executor, what's reasonable, how long they waited. So basically the same thing. And much of the English common law, no doubt, came from Islamic law through Spain. The French law for sure came from Islamic law in part. So specifically, the executor has duties and cannot just decide what to do. Another point on that, but I forgot.
Yeah,
now.
go ahead.
I just want to, I understand that one of the best ways to save tax in Ontario is through the insurance, that maybe through the other means that you have. They must ensure that you pay your tax to the Ontario government before you can actually pass them that. But with the aid of insurance, maybe through the, your insurance goes directly to your spouse or probably to your children. And based on what you explained to us regarding the insurance in Islam, I learned that there is another one that careful. I just want you and Imam to briefly shed more light regarding the insurance in Islam.
It's a
I
it's
think
a
we should
slippery
take it.
slope. In order to save taxes to go through the insurance route, it's a slippery slope in Islamic law because it's not permissible to take insurance that is not necessary, like life insurance. Like as he said, Brother Ibrahim, there are many employers that will give it to you and you can't opt out of it. Right? You can't opt out of life insurance. But Islamically, the majority of scholars have said it's not permissible to have. And there's a small percentage, but we go with the majority on this, that it's not permissible. But some companies that you work for will give you it, and you can't decline it. So what do? There's some people will say, as Brother Reem says, that it's outside of the inheritance because technically it's not in your possession or ownership. It's not. And those are the two things that will then cause the Islamic inheritance rule to be in effect, that you have ownership and possession, either or, just like zakat, right? So they say it's outside of ownership or possession, right? So, but given that the case, you cannot necessarily go down the route of putting your money in insurance because you want to safeguard the taxes that will be levied on it and then direct it to whoever you want without the rules of inheritance going upon it. It's an Islamic loophole that is not permissible. Yeah. Yeah.
Go ahead, sister. Yeah.
Do you have to register for it?
No. So there's no will registration in Ontario. And I'm only talking about Ontario. There's a little bit in BC. And Quebec I don't know anything about because it's the French law. So you don't have to register it. But practically speaking, you should let your executors know where the will is located. But you can deposit with a court in Ontario. But the problem is there's no system to say if another will came after it or which court it was deposited in. So practically speaking, you just have to be organized, keep your will in not the safety deposit box at the bank because then it's hard to access it. It's better to keep it in a home office safe, like those fireproof safes you can get at Walmart, Staples, they're like $100, Amazon, and you should put like passport in there and priceless photos and the will, basically.
Just one thing that came to me too, I'll cover this inheritance. Wills on your deathbed,
Right.
Islamically, is rejected.
Right.
Do you understand? If your father or mother, you are on your deathbed and you're incapacitated, but you can think and talk, as long as you're in that state, any will written Islamically is automatically rejected.
If you mean it's like you start giving away your money.
It's not accepted. Why? Because of the state. The state that you're in, someone else can come and convince you. You understand? Can come and convince you. It's not acceptable Islamically. I don't know about Ontario law.
It depends on
Depends.
it's called undue influence.
Yeah, undue influence.
Right,
Yeah.
So
So Islamic
basically,
law is the Ontario law has looked into it because it's a
Yeah.
it's a Judeo-Christian
Right,
law set,
yeah.
right?
And
So
most of the good stuff.
because
is
you don't
from
want
Islam.
you don't want someone to, because Islamic law will think that someone can take advantage of you in that state, and it does happen. So I've had cases like that where a sibling will come and say, they got this will, my sister, my brother got this will on my father who was on his deathbed, and force them into it. Islamically, it's not accepted. It's not. It's
So
not accepted.
same thing in Ontario. It's called undue influence, and a judge will decide whether the person actually had capacity to make that will, but it's often rejected. But the Sheikh's point reminds me that if you're giving more to your daughter, to give her more while you're alive, you have to do that right before Marad al-Maut, before death sickness.
Before it gets in, yeah.
Because so you have capacity, like Islamically you can do whatever you want with your money while you're alive and healthy. So like Omar gave half his wealth to sadaqah, but Abu Bakr subhanAllah had already beaten him and given all of it. And the famous story that always gives me goosebumps about Abu Bakr radiallahu anhu. But that is while you're alive and healthy. If you're on your deathbed, you cannot start giving away the money. It's too late. Even if you get married on your deathbed, there's rules about, because the wife becomes or husband becomes an heir. So it's tricky even getting married on your deathbed. And in Ontario, we have that. It's called predatory marriages, and there's new laws about that. SubhanAllah. Everything is in this deen, basically. It's already there, but we have to look for it.
This will, what I understood is that it's for 1/3 only.
Yeah, the
So
wasiyah.
how it is going to help in distributing
No.
inheritance?
In the will, you can set apart a third in your will, your whole will.
Okay.
You can set across a third if you want, up to a third,
Up to a third.
for your non-inheritors,
That's right.
right?
Not daughter.
Not daughters, not sons, right? No, they cannot be people who are already inherited from you. So the rest of the will can be about your inheritors, your executors, where you want to be buried, your funeral, and all that, right? If you have debts, you put that in your will also, right? So that your inheritors know where you have debts, right? So that they pay it off. And then you can put in the wasiyah. You don't have to, but you can if you want, that who you want, or some people give to organizations, of the donation up to a third. It doesn't have to be, it could be only up to a third. It can be nothing or somewhat, but you cannot exceed a third of your estate.
What was your question about helping your daughters? You have to do that while you're alive, if that what the question was. Yeah, not from the 1/3, like Sheikh said. I think that
So the will, understand Uncle's question, the will is to make sure that everything is set so that the executor knows exactly who the inheritors are.
No,
And
but are we going to mention the inheritors also? Because
you are.
Yeah, we did.
Yeah.
In
We
the will.
we either
Yeah.
mention them
Yeah.
by name,
Yeah.
like for young couples, I don't name the kids because they're having more kids, inshallah, or they may have. But for clients who probably aren't going to have more kids, we name the children in the will. And then we say the sons are getting this much, the daughters are getting this much, and so forth. Yeah, there's another form. Okay, to the system. Thank you. So yes, it all depends on. This is why the will takes hours and hours to do properly. So that's why we have to charge a little bit for it. So it all depends on each case. What we do is we talk to you for like an hour about what your family situation is, what your assets, what your debts are, like the Sheikh said, how we're going to do it equitably, Islamically, tax issues, and so forth. And then we figure out the proper plan to do it. Alhamdulillah. I'll just take the question from the sister.
My question is, if you have like some jewelry that you don't wear out and you already dedicated it to your children, it's already dedicated to them, but it's in a safety deposit box. How do you address that in the will?
So great
So
question.
it's not part of the pool,
Right.
in my opinion. I don't know what the Islamic treatment
Right.
would be, but would it still be considered part of the overall asset pool?
I'll just talk about from Ontario. Great question, sister. Thank you. I'll just talk about from Ontario perspective. All the Islamic questions to the Sheikh, of course. So Ontario, we do have a clause in the personal use section, personal use items, that can refer either, like if somebody has really like $50,000 watches, we'll like refer to it specifically in the will and so forth, describe it. But most people have they have this piece, that piece. It's only worth maybe 20, 30,000 altogether. they don't have 5 watches worth 50,000 each. Some people have that, subhanAllah. So if it's the normal people for 99%, normal jewelry for 99% of the people, what we do is we say, write a list, we attach it physically to the will, take a picture of each piece, say, I want this to go to this person, I want this item to go to that person. It's not formally, legally part of the will, but we physically just attach it like a paper clip to the will. Now, whether you're allowed to do that, and I'll let the Sheikh answer, the general principle, first of all, is while you're alive and healthy, you can give your property how you wish, obviously not for haram, but you can do whatever you want while you're alive and healthy. So you can give your jewelry to whom you want to while you're alive. If it's but if you haven't given it, if you die with it, then it's according to the Islamic distribution, if it's of significant value, practically speaking. But I'll let the Sheikh answer.
Yeah, so if you have, I'll take this. If you have jewelry and you want to gift it to your children, they're young. So what you would do in a safety deposit box or whatever, what you would do is you would take a picture, or you would put whatever you want to give, you would put it into a Ziploc bag and put a note. This is a gift for so-and-so. This is a gift for so-and-so. This is a gift for so-and-so. So that when the executor goes to that box upon, after your demise, right? When they open it up, they say, oh, this was gifted. You gifted this. And put the date on it, right? So Ziploc bag, this is a gift, so so-and-so, this gift for so-and-so. And Islamically, it's sound because you just gifted it while you were alive, right? That's the easiest path and easiest method for it. Yeah, exactly. It gets excluded because whatever gifts you give of your wealth is not yours anymore.
And here's somebody whispering, what if you're using part of that gift during your lifetime, but you've actually wanting me to gift it to them?
The technical answer to that, you got to ask their permission that you can still use it. I'm serious.
Yeah,
fiqh
exactly.
is very technical. I've studied fiqh for 10 years. Actually, no, I've been studying fiqh for about 25 years. 10 years formally. But I still read. Fiqh is a very technical issue. Very technical. Because you're going to be asked by Allah subhanahu wa ta'ala. So technically when you gift someone something, you cannot, listen, I'll explain this. There's a rule that when you give someone something, you cannot gift it on a condition. It's not a gift then. You can't say, here, I'll give this pen to you, but I need to use it every Tuesday. Or else I won't give it to you. You can't. It's like zakat. You can't say, yeah, I'll give you the zakat, but dinner tonight on you? Can't do it. Can't do it. It's not permissible. You know what I mean? So if you gift it to them, even if they're minors, right, you still have to say to you, if you want to use it, that, this is yours, but is it okay if I wear it? That's all. They're not going to say no, right? They're not. But that's how the fiqh works. Oh yeah.
If one of you have a child and they are non-Muslim, they've been raised in Islam, but they choose not to practice Islam, or unsure of whether or not they're continuing with that belief, and they're raising their children, also there's a grandchild involved or grandchildren involved, and they're also not being raised in Islam, or unsure of their position with the deen. Do they have a right to inherit?
I was asked this question last week in Dallas, actually. So this is my answer for it. If a child is known to be Muslim and have Muslim children, Muslim parents, and they were raised Muslims, unless there's verbally said that they're not Muslims anymore, or you see an action that would take them out of Islam, like prostrating to an idol, that takes them out of the deen. So unless that happens, even if they don't practice, pray, do nothing, read Quran, nothing, fast in the month of Ramadan, they're sinners, but it doesn't absolve them from the deen. It's sinful. It's just sins. Two things take you out of the deen, right? A declaration that you're outside of the deen, that you're not Muslim anymore, and a serious action that is contrary to the worshiping Allah subhanahu wa ta'ala. right? And I mean, yeah, shirk or whatever. It's not like, oh, I don't know, but I saw the Bible on their table, so they're not Muslim. No, nope. That doesn't mean anything. Doesn't mean anything. So it has to be a serious action that anyone that looks upon will say they're not Muslim.
If they come to you and say, I don't believe in La ilaha illallah anymore, what happens?
Takes them out of the faith.
Then they're out now.
Takes them out of the faith. Takes them out of the faith.
See, it goes on.
Because the cautionary thing is we cannot put someone outside the faith without proof that they're outside the faith. If they were Muslims, you understand? You cannot. Likewise, if someone's outside the faith, you cannot put them into the faith unless there is an understand that they wrote something. And we have cases like this. People convert, they don't tell anyone, and then, or they tell one child, the other children don't know, and then they pass away, and then there's a fight over how to bury them. Fight. So we say to everyone who converts, at least here in the mosque, they write. We give them a statement of declaration and we keep it. And they actually write that they want their funeral to be in Islamic accordance, and we keep it here. Because we had issues where that doesn't happen, unfortunately. We had issues like that. Yeah.
I just have to add on that. That's great practice. Ultimately, the executor of the will gets to determine the burial. So they should take into account the person's wishes, but they don't technically have to. But it is a big fight. So it's really important who you pick the executor as the executor. If there's non-Muslim family members and so forth, and it's good. It's fine if there's non-Muslim family members because you're spreading the deen. But there are issues.
There was a case of someone here in Brampton who passed away, a Muslim. His children, he didn't leave a will. His children, some were non-Muslims, some were Muslims. A court appointed one of the non-Muslims' daughter, the eldest, as the executor. She cremated him. And that happened. That happened in Brampton 3 years ago. That happened in Brampton.
In Ontario, if you disown a child, it's also messy. We do have testamentary freedom. So I have a Muslim client who wants to not give to his daughter, but it's not because one of his daughters, but not because the daughter's not Muslim. She just made him really mad about something, and he doesn't want to give her. So I said, Islamically, this is not valid. You can't do that. Of course, in Ontario, he can do whatever he wants. However, I told him, even in Ontario law, it's going to get messy, and a court, what you're doing is opening up your children to fight. Basically, like, do we want our children to go to court and fight? So that's one reason to do the will. And number two, to do the will justly. And number three, to try to mediate any problems with the sheikhs. So I know old school culture, we'd rather be angry at our kids and make them regret it later. Literally, sometimes my mom says that and I have to remind her this is not beneficial, and she comes around. But it's old school. No, I'd rather they like say, oh, I shouldn't, they regret it after I'm dead. That's our cultural way. We should not do that. Try to reconcile differences and so forth. That's just as an aside. Sheikh, brother here first. Yeah.
No, it is a follow-up to what he mentioned. So if somebody declares,
thank you
like
so much,
if
brother.
my son was to say, I'm not a Muslim, whatever, so the inheritance would be redirected to the ones that exclude him, or how does
Yeah, so what happens is that it's as if he's not even an inheritor. He just left off the list of inheritors, he's left off. Right? So if he's the only son and you have daughters, it's no more he gets double that of the daughters. No, it flips. Right? It goes as if he's not even an inheritor at all. Yeah.
Well,
That's a quick question regarding initially when the topic begins, talking about this holographic bits.
Right.
We're talking about the things handwritten, stuff like that, right? And more on top, just mentioned, there is no specific registration required in Ontario. That's what you said, right? My quick question to you is this: people who are having this holographic bits written handmade, right? At on top they have the witnesses' signatures and their own signatures on top. Are they equivalent to the wills which is done by you, or they have still plus minuses, you know.
So the holographic will, you don't even need witnesses, which is strange. You just have to write the whole thing in your handwriting and sign it. And that's the famous case that Sheikh mentioned about the tractor from Saskatchewan.
Yeah.
There was no witnesses. He was dying in the field. That's from like 70 years ago or more.
Yeah.
But, so you don't need witnesses for the holographic will. The whole problem, though, is you're opening yourself up. Number one, there's no lawyer who even knows that you did a will, who can testify. So imagine the will is either contested, that somebody says, like let's say the will says, I gave everything to my favorite son. The other children are going to say, either you made father write that will, or you forged it in the signature. There's nobody else involved in the process. So the problem is it's lost. Nobody knows it exists. Number two, nobody knows under what circumstances it was drafted, if it was undue influence it was called, or the person was like on their deathbed, as Sheikh mentioned, and they didn't have capacity anymore, or was it fraudulently, and so forth. So it is valid. So at the very least, write a will by hand and then sign it. But most of the ones people come to me, they did it before and they said they were going on Hajj or they were going on a trip, they did it. And I'm like, great, you did that because you were thinking about it. But when I see it, it's a disaster in often cases. Like it would have been a mess later. Not because they intentionally did anything wrong. They just didn't do things properly, didn't take it into account if people die out of order and so forth. It's tricky. So, yes, you can do it. You don't need witnesses. You write the whole thing in hand and sign it. But it's important to let know people where it is. But I highly recommend not to do that. Somebody asked me about the templates. There's masajid that do templates. So the template is usually better than nothing, but it's sometimes worse. There was one masjid under previous corrupt administration. I'll put it that way. I won't give you any more hints, but it was in the GTA many years ago. The will, it said if you didn't have kids, give everything went to the masjid. Which is not Islamically correct, because even if you don't have kids, it goes to other relatives.
It wasn't this masjid, by the way.
Certainly wasn't this masjid. But you could only give up to 1/3 to the masjid. So that was un-Islamic. Number two is that the templates themselves, there's you can go to the orthodontist if your teeth are incorrectly structured. Or you can get something off the shelf and put it in your mouth and do it. Now, maybe the thing off the shelf is good enough. Maybe 20% of the time. Maybe even 60% of the time. Mm-hmm. The problem is, you can only go to an orthodontist to determine if that off-the-shelf product was sufficient. But that's fine. You can try it, and then it didn't work, you go to the orthodontist. The problem is if you do a will yourself, there's no do-over. You're dead, basically. So if you screwed up, there's no second chance if you did it yourself.
The thing is because you already mentioned
versus the orthodontist.
Yeah, you're gonna put that piece of paper in that safe box. Right?
Yes, or
inside your road,
whatever.
The second thing, it's been activated automatically after your death. That's
well,
what you said?
No, it's not automatic. The executor has to.
This is what I'm going towards this point now. So basically, you have to appoint some executor. Right?
Yes.
So of course, he will come or she will come.
Yes.
To execute all that stuff right out there.
Yes.
So that's why in that prospectus, I just asked about basically government of Ontario.
Yes.
Respect that whatever's been written.
Yes.
As per your Islamic values,
Yes, depending how you phrase it. Now let me just give you another thing.
But it can be contested.
Yes, we don't.
A holographic will, from my dealings with this, holographic will or wills written by hand are the ones that are mostly contested by the inheritors badly. And they spend more money in the court system than what they're going to inherit. Honestly. Because when there are cases where wills, even that are done by lawyers, are contested. There are, right? But it's the fight for holographic wills is badly contested. It can be badly contested. Real bad. That's why it's better sometimes, most cases, it's better to do an official will that is legally sound.
I would say if you're leaving tomorrow or the next week and you don't have time, do the will yourself. But if you have a couple of weeks before your trip, it takes a couple of weeks depending how busy a lawyer is to do the will. Do it properly for God's sake. Do you do your own surgery? Do you pull your own teeth? So why would you do your own will? Just because it's in English? Yeah, sometimes you have to. Just because it's in English, you think you can do it? Like, I don't go do real estate law or like family law. I know a little bit about it, but I don't do areas of law outside my area of expertise. So, in emergencies, do the will. That great case about the tractor, it was an emergency, he was dying in the field. But if you do it, write it full in hand, sign it, tell people where it is. But for God's sake, don't rely on that, because 95% of the time, they're either fought over, lost, or they're not done properly. So do it properly for $500. You don't have to come to me. There's other lawyers. Do it properly for $500, $1,000. You have like $1 million house. You have a $400,000 business. You even have a $50,000 in the bank, right? You have small kids. If you don't have kids, if you don't own anything, you basically don't need a will. You should still do it, but only those cases I would say do it yourself. And even then I tell them, okay, I can cut the fees this much because you don't have any assets, and change your beneficiary, do this yourself, change the beneficiary designations to the bank. So I try to help the people. The problem is the will to do it properly takes a couple of days of lawyer's time spread out. So, my wife would kill me if I didn't charge, so I have to charge enough to pay the bills at home, right? So, but if you have no money, more money, more problems, they say. You have no money, no kids, do it yourself. But anything over like $50,000 in assets, you own a home, you have a disabled child, you have any children, you have a business, do it. And alhamdulillah, there's no shortage of business, so I don't, alhamdulillah, by God's grace, I don't need more business. Alhamdulillah, but I'm happy to help. And because I want people, my main goal is let's do the Islamic distribution so that we're following Allah's laws, but we do it in a smart, tax-efficient way, basically. So I want to help all of us not sin and to not lose money to the government, basically.
Yeah.
Oh, yes.
I've been waiting for a long time.
Oh, sorry. Forgive us.
How soon after the death of a person does the probate take place? This is the first question. The second part of the question is, let's say all the inheritors, like for example, those parties who are supposed to be benefiting after a person is died, if all of them are at the same table, like all of them are aware that the will has been kept in here, there is a signature, two signatures of non-inheritor witnesses, okay, and the lawyer is already on board also, or let's say the lawyer is not on the board, will the Ontario government accept it?
So yes, it can.
Yes, it can be. The question is, let's say for example somebody dies, okay, and for example in my case, okay, hypothetically, but ours is a joint account, okay, so my wife is already on a joint account, but let's say anything happens, will she be able to operate the joint account?
Yes.
In the bank, withdraw money or something like that, or how soon the probate starts? Okay,
so great question, Uncle. So, probate depends on the county or the region you live in. So where the deceased is last resident, you go to the probate court, or the executor goes to the probate court in that jurisdiction. It usually takes about 6 months on average. Toronto's more than some other areas. It takes longer, 9 months. So to get the will, the certificate for the executor to use this will to distribute the assets.
6 months?
Takes months. Some places that are quieter take weeks. Like
even the will,
everything, yeah. Because so many people are dying, there's only so much court staff. So this is why if you don't have
the person really needs the money.
Yes, good question. So I'll get about the joint thing. So don't worry, but that's how long it takes. That's an Ontario bureaucratic problem.
Okay.
Quieter jurisdictions like country places take shorter. First question.
Okay.
Joint accounts. So husband, wife, joint accounts, as I mentioned, It's good because good to have your bank account. Yes. So, but that's only husband-wife, not parent-child. So people think that if I add my children to the bank account or the house, God forbid, that will make things easier. That's bad to do. Why it is? Because the joint tenancy laws of Ontario apply only to husband and wife, not to father and child or mother and child. Because there was a case in Ontario where the father had $1 million cash in a bank account. He added one daughter to the joint bank, to the account, made a joint with one daughter. He died. The one daughter said, haha, I get $1 million. The other children said, no, you don't. Dad just put you on the account for administrative purposes, not to get all the money. They went to court and they won. And that's only about 10 years ago, or maybe 15 years now. And that is a just outcome because the father, it was unjust if only the one daughter got all the money when there's other kids. So the joint account will continue between husband and wife because this society, as I open the presentation, is based on the husband-wife unit, the spousal unit, not the parent-child. So yes, put joint accounts with the spouse, but people think, like we had cases where the husband's 20 years older than the wife. He thinks he's going to die first. What happens? The wife dies first. So all the planning was with the assumption that the husband's going to die first. And then everything's in chaos. So only Allah knows. Second is that both the husband and wife are eventually going to die. So you still need the will to deal with the distribution because what happens between a bank account between the parent and the child, it's frozen. Pending the court, making sure that the one kid is not entitled to all the money. So imagine you have $50,000 with the one child. That the bank is supposed to freeze that account until they know for sure that they're not supposed to share that money with other siblings or other heirs. So the other so joint account with the children does not help in the will sense. It might help for administrative purposes, which is understandable. Second, if you put your child on the bank account or on the house, God forbid, and the child gets divorced, it's going to get messy. And we're literally in the case with that. I don't do the litigation side of it, but the mediation side. The ex-wife is now trying to get the house as if it was her own when she was only added on by the father-in-law and mother-in-law. The father-in-law is now passed away. And she's claiming the whole house is hers, and it was only like for administrative purposes. This is a big mess. But even without the in-laws, if you put the house with your son gets divorced, the ex-wife or the ex-husband could make a claim. They're not supposed to get inheritance in a divorce from the other parent, but it becomes messy and it becomes open to claims. So make bank accounts joint with the spouse and the house, but not with the child, even if he doesn't get divorced. If there's creditors, he's in business, he gets sued. Now he owns your house. That house becomes part of a creditor claim. Sorry, yeah.
What about the lawyer's signature? I mean, or lawyer's notification? Like the family knows that the will is here.
Yes.
And all the sons or all the inheritors, they know that the will
yes, good.
has been written by
good. Yourself or the lawyer,
yeah. So is that enough?
It could be enough. Yes, it could be enough.
Yes. Only if the inheritor, one of them, contests the will, right?
Yes.
The hologram will.
Yeah, holographic. Right? Yes.
Yeah, hologram.
Yes. But as Sheikh said, you're opening up yourself to more problems. But it sounds like it's okay, Uncle. Yeah. But I can't give you a legal opinion without looking at everything and seeing.
Exactly.
But generally, I'll repeat the same thing. Do the holographic will only if you're going on a trip in the next 2 weeks. If you're not, please do it properly. Allah knows I'm saying you don't have to do it for me. I can't do everybody's anyway. But do it properly for God's sake.
Last portion of the question is, like, when do the bank get involved? Like, for example, you already said that it takes 6 months
on average
will to come over
to be probated,
start processing and so on, right? Then banks get informed later.
So how it works is that a bank will freeze accounts,
right?
will freeze an account that's not joint with the spouse. However, they will allow checks to be written from the bank from the account, even if it's frozen, for funeral expenses and so forth. There's some exceptions. And small accounts like 5,000, 10,000, they look the other way and they just let people keep using it. But every bank has a different rule of a threshold where they'll freeze the account, and it will take six months often to get the right of the executor to be able to access the account on behalf of the estate. However, the bank will allow some expenses to be paid and so forth, but it's messy. So now, if you don't have a will, what I was about to say is that this process takes longer because you have to advertise for creditors. Like Islamically, at the janazah, people always say if there's any debts, come to the executors, we'll see if they're real debts and we'll pay them. If you die without a will in Ontario, an executor has to come forward. There might be fights among the executors, potential executors. Second, once the executor is approved, which takes longer than if there is an executor named, then the executor has to advertise to creditors in the newspaper. There's certain protocols. Anybody's owed money by this estate. Because there's nobody fully responsible without a will and naming the executor. Otherwise, the executor is responsible. So you have longer delays than 6 months than if there's no will. If you do the will yourself, you're opening yourselves up to that. Brother.
So guardianship of a minor.
Yes.
You have to be a resident in Ontario.
Okay, great question.
So how does that work?
So how it works in Ontario is the person named in the will becomes the interim appointed guardian. So the appointment is an interim appointment for 90 days. So whoever's named in the will, wherever they are in the world, is the legal guardian of the minor child. And minor, we really mean under 16 in this society. If you're 16, 17, 18, you practically speaking don't need a personal guardian of your custody, but technically you still do. So should the person be local? I would say yes. Why? Like, let's say Pierre comes to power and makes it hard for Muslims to come from overseas, like Harper used to do. God forbid. If your guardian is in Pakistan and can't get a visa to Canada, then you're in trouble. Now, I'm not saying you shouldn't name your brothers, whatever, in Pakistan, for example, but it shouldn't be the only person on the list. You need more than one person, and you should include, if you have no family in Canada, and we have situations like that, or in a Western jurisdiction where they can come without a visa, you should name a close family friend who could act as the interim guardian until the other family members can come here. How it works after the 90 days is a judge has to approve that person becomes the permanent guardian of the child. Normally, a judge will rubber stamp the parent's choice. So another reason to name guardian, have a will, is to name the guardians properly. There's also complicated issues if you're divorced and there's both parents and they have different guardian appointees. So try to name local people, name similar values, have more than one person named. And just be careful about this process, basically. Thank you for the question.
Jazakallah khair for your presentation.
Thank you.
Very informative. How often should a will be looked at or updated? And the reason I ask this is because we got a will done 13, 14 years ago, Islamic will through a lawyer. At that time, we had 2 children who were named specifically. We subsequently had one more, but he was not obviously in the will.
Right.
So do I need to go back to a lawyer or to get that updated?
So great question, brother. I should have mentioned about how often to review the will in the presentation, so thank you for raising it. So I'll say generally, and then I'll try to address your specific question. Generally speaking, every 5 to 7 years you should review your will as a rule of thumb, to see if you need a new will. You may not need a new will, but just keep your mind, it doesn't have to be 5 to 7 years, I'm just saying as an example. What we recommend is that when you have major life changes, more children, God forbid you get divorced, unexpected death, unexpected disability, say your child became disabled later, that is a time for sure that you should look up for potentially drafting a new will. Whether you need a new will or not, it depends what's in the previous will. Now, to your question, brother, it depends on what's in your will. So my practice is, if the couple is in their 20s and 30s, even 40s, depending, I don't name the kids because they may have more kids. I draft it broadly, say sons and daughters, children. If they're in their 40s and 50s and older, I name the kids. But I tell them, if you have a new kid, if you adopt a kid, we may have to do the will. So to your question, the lawyer, and don't name the lawyer or anything, the lawyer shouldn't, if you're, the lawyer should not have, well, it depends on circumstances. Let me just say it this way. It's better not to have named the kids at that time. But if it's done now and the kids were named and it wasn't also said and any more children, then yes, you need a new will because your new child is not included. But if the lawyer drafted naming the kids but also allowed for the existence of new children, you may be okay. But I would have to review your will, which I can do no charge. Anybody here today, review the old will, no charge. And then we can decide if you need a new one or not. If you do a business and it's incorporated and you have a lot of money in the business now, alhamdulillah, you should get a new will for tax purposes and so forth. Also, executors change. Like you name your brother 20 years ago to be your executor, but now he's like 75 and you're 60. He's not the ideal person to be the executor. Your children have grown up. So generally, 3 phases in life will. Say, you and your spouse, first will. You and your spouse and young children, second will. Third will, you and your spouse, children are mature. Those are the 3 general phases. So people normally need at least 3 wills in their lives, maybe less, maybe more, if other unforeseen circumstances happen. So maybe you already missed the first 2 phases. You're in phase 3 of your life. You don't have a will. That's okay. Do the will now because your children are mature. And maybe you don't need a will now for the rest of your life. But probably in the first 2 phases, later on you'll make your children the executors because your brother's old and your children are the ones who are getting the money and should do the work anyway rather than your brother, for example. So every question depends specifically. Thank you.
I just have a question. You said, if you don't have much to begin with, and the Imam said, like, if you have clothes, whatever, you should write one. Is it possible just to write it with your hand?
Yes.
And then can you say, like, in general, like, I want to divide this Islamically, like, through the Islamic will?
So this is tricky. Good question, brother. So if you have less than 50,000 in assets, no house, no significant cash, no spouse, no children. So all those conditions, then I say, yes, maybe you can do the will yourself. If you just say Islamically, it's tricky because there's different schools.
There's different schools.
What is, there's also, who is going to determine it Islamically? Yes, you name the executor. So how, and this is why the programming was helpful, subhanAllah. I think why Allah sent me into programming first is we draft a number of cases where we specifically list the first 3 cases that statistically are likely. Some when people have, it's actually trickier for me, the guy who comes with, he's not married and no kids, and he comes to me to do the will, he thinks it's simple. For me, it's harder because he has no son yet. Yeah. So, so then in those cases, I literally have drafted like 10 cases. So that I do, and in the last case, I say Islamic. Why do I do that? Because I don't want a judge to say, what the heck is all this? A non-Muslim racist judge who will just throw it all out. Or I don't want like a person who I won't name, but an Islamophobe who's passed away, thank God. He would come and try to say this will is against public policy. We don't want to do Islamic wills in Ontario. Or in U.S. states, the occupational apologists who want to Palestine, who want to steal all of Palestine, they've riled up the American people to be hateful against Muslims, and they pass laws in states to make Sharia law illegal, unconstitutional. And then CARE in the U.S. has to go and fight them. So let's say that passes with a future government of Pierre, God forbid, where he says Islamic law is unconstitutional. Then if you just wrote Islamic law in your will, it's going to be invalid in Canadian law. We won't be able to take advantage of the testamentary freedom I mentioned. So some wills and some of the templates, they make a big song and dance, I would say, astaghfirullah, of saying, I'm Muslim, I do this and this and this. They draw attention to the will Islamically. I would say that's not a wise strategy because we don't know our future in this land. I do low-key Islamic will. So I'm doing Islamic wills, inshallah, without announcing it up front too much because I don't know what the future would be. Because my goal is to make you be able to pass your stuff off Islamically to your children without an evil Islamophobe blocking it or a judge throwing out because it's too vague. So it's a bit of an art.
So like in my case, let's say I just have no siblings, just my parents.
Okay, alhamdulillah.
So I would just like look at what I have right now and just write it according, like get the details from like the Sharia or an Islamic law and get the details and just write it according to that and not saying like it's based off Islamic law.
You could. But brother, if you have, you don't have to publicly say your stuff, but if it's less than 50,000, you could do that yourself. But even if you have no spouse, no kids, if you own like, you have this much investments, this much house, then that shouldn't apply. But if you have no spouse, no kids, and no assets over 50,000 as a rule of thumb, then your father gets 2/3, your mother gets 1/3. But it gets tricky. What happens if the father dies? The mother, depends how many siblings you have. The mother's shares can go from 1/3 to 1/6, depending on no siblings. Then I believe your mother will always get 1/3, but Sheikh, we might have to look into that. But Sheikh might know off the top.
It will then go to aunts and uncles.
Yeah,
it goes sideways then.
Yeah,
so my mother gets 1/3.
And grandparents depends if your father's alive or your mother's alive. The true grandfather, the true grandmother. It's complicated. So. We can talk rather specifically.
So you said like if your father dies, so my mother would get 1/3, and then the rest would be split among
your father's brothers and your father's sisters.
Those are the male relatives at the side.
Okay.
It's your case a bit tricky.
That can get complicated.
Yeah, it's okay, but the straightforward thing if your father survives you, but you're young, obviously we're younger than our parents and statistically unlikely, so your case it gets tricky too.
Yeah,
so even a simple case is tricky.
Even if your father's brothers are not alive but they have sons, they will then inherit down.
Right.
So it gets tricky.
It's more complicated actually. It's heavier.
It may be simpler because you don't have siblings, but because you're young, that case is actually more trickier than having siblings.
Yeah, I was just wondering if there's like something if you just write briefly.
So but we take care of your situation. But if the assets aren't significant, then I understand why you don't want to go to the expense. I understand. Yeah.
In terms of a joint account with the spouse, how do you identify assets, or is there a way to sort of?
Yeah, this is a great question Islamically in Ontario law. So I'll just do Ontario law and then the Sheikh can, of course, do Islamically. So Ontario law, it's winner take all. So whoever dies first loses everything. The second one, the last man standing, but say last person standing gets everything. But Islamically, we have to reconcile. But you have to decide up front who owns what. So, and I'll just say quickly what I've heard and then the Sheikh can correct. So you have to decide. So if, let's say the stereotypical case, the husband earned all the money and the wife was at home with the kids. So even if you have a joint account, if the husband dies, it goes according to his heirs Islamically, even though in Ontario she gets everything if it's joint. So then she's a trustee who has to give it to whomever his heirs are. However, this is what Imam Nadwi said of Al-Falah and Iqna many years ago. He said he recommended in front of all the witnesses. It's not a fatwa because he didn't write it down, but he said in front of witnesses like you guys. He said he recommended in those scenarios the husband give half of his money to his wife while he's alive and healthy so that she's protected in this society. So he just says, "Oh wife, I give you half of my money. Even though I earned it Islamically, so technically I own it Islamically, I give you half of the property so that if I die, when I die, you already own half because I gifted it to you while you're alive, but the other half now you divide up Islamically." So he recommended that. Somebody like you asked Imam Nadwi the follow-up question, and he's mashallah a very high-level scholar and traditional, mashallah. He said, the questioner said, "Can I give all of the money to my wife then?" He said you could while you're alive and healthy, you can. But he said that might cause injustice to your other heirs. So he recommended not giving it. But mashallah, he recommended giving half of it. Maybe would you like to... Sorry?
It's a fluid thing, right?
It's a fluid thing. It changes. So you have to do it every year. So it gets tricky. And also, if her parents are alive and you gave everything to her, you gave half to her, then she dies unexpectedly. Well, it goes up to her father and mother gets 1/6 if you have kids. And that's one of the cases where the male and female is the same. If you die, you have father and mother and kids, your father gets 1/6, your mother gets 1/6. And some of the Sahaba thought the mother should get more, actually, but they were the minority, so that didn't become the dominant opinion. So all of this gets tricky on the joint assets, but generally, I still recommend you keep the assets joint, but you can work it out. Let's say the wife is making 25% compared to the husband. And there's some cases where the wife is making more, and that's more and more common today, subhanAllah. So then you just say, okay, you earn 25%, so your 25% is what you own already. The other 75%, I'm gifting you an extra half of that 75%. The further, there's something else escaped me, but we inshallah, come back to me. We as part of the process, we reconcile this and we figure all this out to decide how we should distribute it Islamically and the oaths we take and so forth. But just generally, still keep the property joint with your spouse. I would still recommend, but not with your children, basically. Thank you.
Islamically, if you have a joint account or ownership of a joint house, Islamically, if the executor, let's say it's myself or an imam or someone religious, and you pass away, and there's nothing to determine in writing what was meant by that joint account or that joint asset of the house, half of it is hers. It's not half of it is hers, the other half go into inheritance, in which she'll get a share. You understand?
That's not even like doing it in life, right? Like, an executor can make that determination.
Well, no, the executor will look and say, well, okay, the house was owned by both husband and wife, you passed away. There's bank accounts that are owned by both. Well, I don't see any notes here that my wife was put on this account just as an executor, right? Or my wife was put on this account, this house, just as an executor in case I pass away. There's nothing. The executor, a Muslim executor, will say, no, you intend that half of it is hers.
That's what we recommend. Exactly what you're saying.
You would have to determine that, because there's no way to go back and look and think what your intention are. We don't know. So our thing is that, it's joint, half of it is hers. Half of it does not go into inheritance. The other half goes, in which she'll get her share from that half.
And that might be the most just solution. I think it's great the Sheikh's doing that. Yeah, because that's the most just.
I've had questions like this, and that's how.
And Imam Nadwi recommended that.
There's nothing there, because you don't know. Because if you say that, no, he technically meant because you weren't earning anything, and it's all his, but you had a joint. He was just. You can't put that intention of someone who you never heard it from.
And that's regardless of whether you're not put it in the will, right?
Exactly. Right, so you would have to write it. You would have to write it out and state it to them, write it formally, and keep it so that someone knows it.
I have a question.
Yeah.
If I have a will from Quebec, and a new Muslim, the rest of my siblings, my parents passed away, are non-Muslim. I have a wife and we have children. We're residing now here in Ontario. Do I need to redo it because in Quebec you weren't sure about that point?
Right.
It is actually the case that you do have to register,
right?
And they have a registry for wills.
Okay, great.
It's kept with the lawyer who drafted the will.
So
what would be my case? I would have to redo it now here in Ontario?
So, great question. So the question was, you were in Quebec and now you're here.
Yes.
So in Canadian law generally, where your assets are located, if they're real property. So if you have real estate in Alberta, Ontario, Quebec, whatever,
yes.
the law of that province will govern that real estate. But it's different rules from movable property, like you have a gold bar with you that you moved around with or something. So in your case, brother, do you still have assets in Quebec? Do you own a house or any real estate? So now,
not here, not there.
Okay, so your life is simpler. So normally, generally, sometimes. So this is a good question. I should have answered it, talked about it earlier. You can have multiple wills in different jurisdictions. So a lot of people have family property in Pakistan, India, Egypt that they inherited from their parents. So we do the Ontario will, it may or may not be valid in another country. So what I always recommend is you have an Ontario will, which will cover US, UK, or say US and Canada. An Ontario will, because the laws are similar, it'll cover US and Canadian law, Canada generally, leaving aside Quebec for a second. But if you have significant assets in Turkey, a lot of people have assets in Turkey now, mashallah, Turkey, India, Pakistan, Egypt, go talk to a trusted lawyer in that jurisdiction and get a will in that jurisdiction. Just make sure the later will doesn't cancel your previous will. So we have to do it carefully, because the first line of most wills is to cancel previous wills, so you're starting fresh. So you don't want to accidentally cancel your Ontario will by doing the Pakistani will, or vice versa. To your question, brother, generally speaking, if you move to a new province, you should have, from Quebec to an English province, generally you should have a new will and vice versa. However, you may not need it. We'll have to talk more privately about the nature of your assets, but maybe you can escape. Do you have children?
Yes.
MashaAllah. How old are they?
Oldest is 20, youngest is 12.
12. Okay, so you still have minor children, so I would be careful, depending what the Quebec will said. But we'll talk privately more. Yeah. Thank you for the reminding of this point.
Okay, then we'll wrap up.
Yes. I just had a plug before we wrap up.
Yeah. This is the final question.
Yeah, he brought a good point.
Yeah.
If you have wills outside of Canada, do those take precedence over the ones in
So the later will, if it revokes the previous will, takes precedence over the earlier wills. So if you have a will in another jurisdiction, you have to let your lawyer know you have that. And I ask about that, but it's a good reminder that I should make sure it's in the questionnaire. So we have to be careful not to cancel the previous existing will, but we try to reconcile the two. My plug was for the Canadian Muslim vote. I used to be one of the founders of that. I'm wearing their socks. So there's an election in Mississauga for municipal. So if you live in Mississauga, or you own property in Mississauga, or you have family and friends in Mississauga, there's a mayoral election, and I'm supporting Carolyn Parrish because she's been advocating for Gaza for 25 years. She went to Gaza as an MP in 2002 and wrote a report saying how bad the Israeli military occupation was. That was in 2002. She was also an MP in 2003. And she told Chrétien, if you join the Iraq war, I'm going to sit as an independent. And that helped strengthen him against others who wanted to join the Iraq war. So please, if you're living or own property in Mississauga, please vote. Voting is today, next weekend, and June 10th. Sorry, that's my political plug.
That's a good plug.
Carolyn Parrish. Parrish.
Okay, so we thank you all for coming. We thank Brother Ibrahim Daniel. I think it was beneficial. Alhamdulillah. Alhamdulillah. So we thank him. I mean, it's Saturday. It's his family day. Alhamdulillah. He has children, mashallah. But and he does a lot of good advocacy for the Muslim community. Lots of it. I'm on a group where he writes a lot every day, alhamdulillah, especially for Gaza and other places in the world. So it's not just he does law. He does a lot of advocacy work for the community, and it goes hidden, because I think he wants to keep it hidden. But we all know. So we thank him for coming, mashallah. So if you haven't signed your email and stuff, and you want some information, you want to do a will, I'm going to do my will with him, inshallah. Inshallah. So it's our pleasure for him to come in our honor. Inshallah. We'll have him back some other down the road. Inshallah. There you go. Yeah. The other lawyer here in Brampton. Yeah, so inshallah ta'ala, may Allah subhanahu wa ta'ala protect him, provide for him, safeguard him. May Allah subhanahu wa ta'ala reward him tremendously with much reward. Reward all of you and take you back to your family safely and soundly. May Allah subhanahu wa ta'ala help us to continue the process of learning. And may Allah subhanahu wa ta'ala strengthen our community and strengthen our communities abroad and strengthen the ummah and relieve them of all the oppression and all the terrible things that are happening to them and help them to overcome the challenges that they face. Ameen. Ameen. نستغفرك ونتوب إليك وصلى الله على سيدنا محمد وعلى آله وصحبه وسلم. جزاك الله خير.